Hi, Alexandra. What gave you the idea for this particular discussion? I know the relationship between social workers and their legal team can be complex and long and difficult on some occasions. So, what in particular prompted you to think this was a good idea for us to talk about it?
I think there are two things. Firstly, that it fits in with the child's journey through care.
Yes.
Because the only way a child can start any sort of journey in the care system is with a legal framework. Yep. Even if it's just a Section 20 agreement, there's a legal framework about how that is created. And of course, you've got the care proceedings and placement and adoption proceedings, and all of those things require the involvement of the legal department, require the involvement of court to underpin whatever arrangements as children's services think is appropriate for that child. And then it really came out of the agency decision maker workshops that we've been doing.
Oh yeah.
We've had the opportunity of going all around the country meeting ADMs.
We have.
Dozens and dozens of local authorities and RAAs by now.
Yeah.
And one of the common themes was quite often that legal departments are telling children's services what they can't do. And I've heard one or two which I found really surprising. So you've got somebody saying, oh, we were told that early permanent placement wasn't appropriate for this child, or that this child shouldn't be the subject of a placement order application.
Yeah.
And they really surprised me because they're not things that legal departments are responsible for. They're decisions which local authority children's services departments are responsible for. And to be told that a child isn't suitable for early permanence, for example, is not something that a legal department should be doing.
So you think they're almost getting involved in the care planning?
You do get that impression. There's obviously a place for legal departments in care planning because you've got to be able to present the case in court in a way that's going to convince the guardian, the parents, the court that this child should follow a certain pathway. And that's no use if you don't have the evidence, you haven't made the right applications, you haven't got the background to support a particular legal application. But that's only a very small part of the legal planning meetings, only one of the planning meetings which takes place, and there's only a very small part of the planning process. So, by the time you've made the decision, children's services have made the decision that a case needs to come to court and there needs to be a legal framework around this child's life, there will have been significant experience, direct experience from a social worker with the family, direct experience of the child, efforts to divert the family's pathway away from legal proceedings. And all of these will have taken place without the lawyers being involved.
Yeah.
So you've had all those discussions, you've had the experiences with the family, you've taken it back, the social worker's taken it back and discussed it with their manager, the manager's gone through that decision-making process to a senior manager usually to authorise the issue of proceedings. And the lawyers only come in right at the end of that. So they don't have all the background, all the experience of the family and how you've dealt with them up until the point at which you involve the legal department. And those decisions should be made very carefully. Obviously intervening in a family's life is a huge thing for children's services to do. And you should have the confidence in the system that you're part of and the way in which decisions are made. So obviously, sometimes the social workers don't agree with the decisions, but they will have been part of the discussions.
Yeah.
And hopefully parents will have had some input into the plans at some point as well. And it should be presented as a package of this is what we want to achieve to the lawyers.
So the social work teams are instructing the lawyers as in any other legal scenario where you go to a lawyer to sell your house for you, for example, you're instructing them. So the social workers are instructing the lawyers. Is that the case?
Yes, it's still, although you're both working for the same local authority, it's still a professional client-lawyer relationship.
Yeah.
And as long as you're not instructing them to do anything unlawful, then lawyers should take your instructions. In the same way as if you're selling your house, the lawyers don't suddenly take the garage out of the bargain without getting instructions from you to do that or whatever it is. And the the same applies for lawyers and social workers. You don't suddenly change the parameters of what you're going to do with the child or what you think is in the best interest of the child just because the lawyers think that it should go a different way.
Yeah, but there are times, particularly when you get into the court arena and the proceedings themselves, when social workers might feel under particular pressure to adjust some of the plans that they came with originally. For example, the arrangements for staying in touch with their family, or a viability assessment that's been carried out. The court may request that another one's done because they don't necessarily accept the social worker's findings. So there are times where they come under particular pressure in the court arena to change their plans, aren't they?
Yeah, and everybody's under pressure in the court arena. The courts are under pressure themselves.
Yeah.
The courts are under huge pressure to try and deal with all cases within 26 weeks. They're not meeting those targets in the majority of cases. They're overloaded and understaffed, like so many other areas of public service. And that pressure gets passed down via the lawyers to children's services. But I think when you're sending a lawyer into court, it's the primary, going with the first hearings, the primary objective is to obtain an interim care order. You've decided the child needs to be removed from the family, you need the lawyer to go into court and get an interim care order. They haven't been part of the discussions about why you've decided that a particular contact arrangement is the best for the child, how it can be managed within all the other demands on the contact service within a local authority. It becomes very easy when you get to court and then perhaps the mother says, well, I accept that this child may have to go into foster care for a few weeks, but I'll only agree to that if I can have 4 times a week contact and the care plan says 3 times a week
so
contact.
It almost gets used like a bargaining
It does.
tool.
It does. Mm. And if you're focused on just getting the order or just getting the child, just having the child removed from the situation, then there's a lot of pressure on the lawyers to agree to that small change in the care plan.
Yeah.
And they pass that pressure on to the social worker.
Yeah.
They're not looking at the wider picture. I think that's probably true even if you're just dealing with local authority lawyers, but it's particularly true if you've got an independent barrister instructed as well, because they will have even less of the originating information and background on which the decisions have been made. And yes, it does end up feeling a bit like there can be bargaining chips.
Yeah.
With contact, maybe that might be a minor adjustment. But there might be good reasons why there has to be a major adjustment. Perhaps the child is seeing another family member on the 4th occasion when there's an available contact slot, or the child has after-school activities that are really important for them to maintain, so they're not too disrupted. And those are things which the social worker and children's services will have considered and decided on setting their care plan. I think one of the really important ones where it might make a huge difference to a child's life is where there's been a decision for early permanence. And it can be fairly obvious that the child needs to be removed from the family home. And then the local authority, they have the legal duty to consider early permanence. If they've done that and decided that, yes, this is a child who may, in the end, be adopted, and if that is the case, it's in their interests to have just one placement throughout the whole time of the care proceedings, then their care plan could be for an early permanence placement. Often, you do get guardians, you almost inevitably get parents who are petrified by that idea because they think it means that child is almost certainly going to be adopted. And they will say, yes, we'll agree to the child, or in the courts will say, we can agree to an interim care order, but we don't think that the child should be placed in an early permanence placement. And that pressure will be put back down the chain to children's services. And actually, it's not something that they should be giving into, because the decision has been made that if the child eventually becomes adopted, it will be hugely beneficial to them not to have moved placements throughout the currency of care proceedings. And it's not something that anybody can get an order to prevent doing. There was just pressure.
It's hard, though, for social workers, isn't it? Because we know that there's a lot of turnover of staff in frontline social work at the moment. So, that they may be younger, or they may be newly qualified, and gone are the days where your manager used to go with you all the time to court. it may be that the social worker's there on their own, and it's difficult, isn't it? And how that turnover of staff, is that now impacting the legal teams as well?
I think it does in two ways. Firstly, that sometimes, especially if there's a high turnover of staff or a case is moved around from different teams, the lawyer can feel that they're the only one who's actually followed the case all the way, followed that child through. And so they have some authority to make decisions or to agree a certain course of action with other parties, and the newly arrived social worker doesn't know the case as well as they do, therefore there's another source of pressure. But also I think you're finding that there aren't as many long service lawyers as there used to be. Across the whole legal sector, the number of childcare lawyers is reducing. There aren't as many in private practice, moving into local authority practice. They're all reaching a certain age and retiring.
Those relationships are not built up how they used to be, because they used to be those long-term social workers who knew the legal team, and those relationships were there, so they trusted in each other's judgments and respected each other's practice, etc. And those relationships have shifted, so there might be people that you've never met before.
Well, there was always that possibility, especially if you're instructing counsel.
Yeah.
They're not always the same people. They're not always from the same chambers even. So there are times when you need to fall back on the formal client-lawyer relationship.
Okay. Yeah.
Rather than the sort of common purpose that there might have been if you're working a lot with the same lawyers and the same social workers.
Yeah.
But regardless of whether you've only just met them once or you've been working with them for 10 years, it's still children's services which give instructions to the lawyers. And the lawyer's job is to work out a lawful way of achieving what children's services have decided is in the best interest of the child, not to suggest alternative outcomes for the child.
Yeah.
And suggest alternative legal frameworks, because that's their job. That's if somebody's saying, we want this child to remain in this placement, but the foster care is no longer approved, then it's the lawyer's job to say, well, you can make that placement by child arrangements order.
Yeah, because there are some situations where the local authority or the children's service department may feel it necessary in the best interest of the child to, for example, have an unlawful placement.
Yes. I think we've all come across those situations, particularly Reg 24 kinship carers who haven't been approved as foster carers, but at the end of the proceedings, there's a fairly high chance that an order, special guardianship order will be made and the child will remaining there. So moving the child for maybe 1 or 2 weeks until the final hearing is not going to be in the child's best interest, put them into a different foster care or whatever. But leaving them there without going back to court and achieving a different legal framework is unlawful. And it's for the lawyers to advise that it's unlawful, that it's not something which should be happening unless it can be fixed in with an alternative legal framework, in which case that's something for them to suggest. But it's actually Children's Services Department that make the decision about whether or not the child should remain there.
Okay.
But they do need to be fully aware of the legal implications of that. And if it's something which does carry a high risk, if the carers are being turned down as foster carers for something which really shows the child shouldn't be placed there, then the lawyers have the option of taking the case to the monitoring officer, somebody within the legal department, usually a head of legal, whose job it is to make sure the local authority doesn't take any course of action in any sphere that could cause significant reputational or financial risk. And so they have that lever to pull if something is being done unlawfully at great risk. Usually it's something which doesn't carry a huge level of risk.
Yeah. But
they still need to know that the legal framework is there, and there are alternative legal frameworks that might be possible. But if a lawyer, as a lawyer, you've given all the advice about alternatives, about the unlawfulness of a placement or the unlawfulness of course of action, it's still for Children's Services to make the decision about whether or not to pursue it.
And the other scenario where I think we heard as you referred to training agency decision makers around the country, I think something that came across in particular were the time scale pressures and people being asked to make an agency decision for a child in respect of adoption in 48 hours, or carry out a viability of a potential carer within 10 days, or 2 weeks, or all of which seem very short timescales for carrying out things which have huge impact on a child and are potentially life-changing decisions. And it seems wrong not to be able to give them those considered and reflected decisions when you're doing those pieces of work. And yet we know that social workers are put under huge amounts of pressure to go away and get an agency decision, or go away and carry out a viability and come back in 20 days.
Yes, I think that's something that can be really difficult, because often the social worker who's in court is not the social worker who's going to be carrying out the viability assessment. They're not going to be the agency decision maker. So they're being asked to agree to something which they haven't had the opportunity of fully considering. And they are getting that pressure. You do get that pressure. The judges are under pressure. The judges have got this target of 26 weeks. They're being put under a lot of pressure to try and meet that target. And the President's guidance a few years ago made it very clear that you should have 12 weeks to carry out an assessment of a potential special guardian. That made a difference for a bit, but again, they're trying to balance that guidance against the pressure they're under to get cases heard within 26 weeks, and that's not always compatible. So they're putting pressure on the lawyers in front of them to agree on behalf of the local authority that things should be done on a much tighter timescale. And quite often you will get the lawyers saying, well, I'm sure that's all right, and just turning around to the social worker and saying, that's all right, isn't it? And you're not given that chance to have the discussions. I think it's a confidence thing for social workers to be able to say, I can't make that decision. I can't allocate that person. I can't tell you about the ADM's timetable. We have to have 5 minutes. And it's always open to a lawyer in court to say, please we'll have 5 minutes to take instructions. And you can go out of court and you can make phone calls. You can get the support you need from your manager. You can get the information that would enable that decision to be made properly. Is there somebody, could you chop 2 weeks off an assessment? Is there somebody who's actually unexpectedly available and can start tomorrow and get that timescale done? It's possible, but you can't say, we can reduce it 2 weeks just because you're being asked to do so. You have to. So
what it comes back to is social workers having the confidence in their own plans that they're actually asking the lawyers to put into practice,
and their own organisation, the way in which things are done.
So have confidence in their own procedures as well. Yes.
And there's something about the court arena which really saps that. If somebody walked in off the street into a social work office and said, we need an assessment done within 6 weeks, the social worker sitting on the front desk on duty that day is not going to say, oh yes, I can allocate somebody to do that. But somehow sitting in court, if the judge says, we want somebody to do that within 6 weeks, that social worker is expected to make that decision, be able to see, yes, we've got somebody free, we can do that. We'll be able to get all the checks back in time. And it's simply not the case. Just being in court doesn't mean you have to take the decision in a different way without the same sort of thought and examination that you would in any other resource. And yes, they're pressured environments, and the lawyers are guilty of putting, they put pressure because they're focused on the outcome for today, whereas children's services have to be focused on the outcome for the whole child, for their entire journey through the care system.
That's a really good way of putting it there, that you shouldn't change your decision just because you're actually in a court arena. It's despite those pressures.
I think we're all guilty of doing that. We act in a slightly different way in court.
We do. Thank you very much, Alexandra. It's a good conversation.